Hello everyone. For this presentation, I'll be focusing on the competency to be executed and the competency to participate in or waive appeals, as discussed in Melton et al. In Psychological Evaluations for the Courts. So the first slide is about the competence to be executed and the legal standards. Competence to be executed was founded in the Supreme Court case Ford versus Wainwright from 1986. In this case, the court decided that executing an incompetent individual violates their Eighth Amendment rights to against cruel and unusual punishment. And according to this standard, a defendant must have an understanding of the fact that they are going to be executed and an understanding of why the execution is going to happen, specifically that it is the punishment for their crime. However, Melton et al. Emphasizes that awareness alone does not equal competence. A person may be able to state that they are being executed, yet they can still lack a rational understanding of the connection between their crime and their punishment. Next, we have psychological testing and evaluation. When evaluating a person's competence to be executed, Melton et al. Notes that there is no single standardized test that definitively determines someone's competence. Such evaluations are based on structured clinical interviews, behavioral observations, and individual background information. And there are two main evaluation tools being used to determine one's competence to be executed. And the first is called an interview checklist for evaluations of competency for execution. This checklist touches on four topics, such as understanding of the reasons for punishment, the understanding of the specific punishment, the ability to appreciate and reason in addition to simple factual understanding, and finally, their ability to assist an attorney during trial. And the second tool is called Ebert's Competency to be Executed Rating Instrument, which helps guide evaluators in assessing the defendant's understanding of 8 questions of functional legal abilities and 4 clinical inquiries in order to examine the defendant's understanding of execution and its purpose. Melton et al. Also highlights the importance of assessing the steadiness of the defendant's understanding over time. Competence must be stable, not fleeting, or dependent on temporary improvements. There are some ethical concerns that are important here. Forensic psychologists and evaluators must remain neutral, even though the outcome of their evaluation may directly facilitate an execution. Melton et al. Touches on the controversial topic of the death penalty, and if some forensic psychologists have certain opinions on the matter, then they do not participate in competence to be executed evaluations. Next, we have treatment of incompetence. So when a defendant is found incompetent to be executed, the courts must then address whether and how treatment should occur. And in the court case of Perry versus Louisiana, the Supreme Court held that forcibly medicating an inmate solely to make them competent for execution was unconstitutional. And then in Singleton versus Norris, the court allowed involuntary medication when the treatment was justified for medical reasons, even if a side effect of that treatment had stored competence. This raises the question of whether competence being restored through treatment is deemed as forced and unethical. And then we have competence to participate in or waive appeals. This arises when a defendant chooses not to challenge their death sentence. These defendants are often referred to as volunteers because they are volunteering to waive their rights, usually due to feeling depressed, after sentencing. And then we have a court case, Reese versus Payton from 1966. The court held that a defendant must have the capacity to appreciate their position and make a rational choice about whether to pursue or abandon further legal proceedings. This is all a form of decision-making competence. Melton et al. Emphasizes that the evaluator's role is not to judge whether a decision is wise, but whether it is rationally made. Importantly, mental illness alone does not render someone incompetent. For example, depression or despair may be present, but incompetence is only found when a mental illness substantially impairs the person's ability to reason or and understand the consequences of waiving appeals. Finally, to end, I want to pose this discussion question. Do you think the state should be allowed to restore a defendant's competence with the sole purpose of allowing them to waive appeals or to be executed? This question highlights the central tension discussed by Melton et al. Of the balance between respecting autonomy, protecting vulnerable individuals, and ethical limits of forensic evaluations. And then also, I have included a short NPR audio segment and news article on the execution of Scott Panetti. Panetti's case illustrates the challenges courts face when determining whether a defendant's understanding is irrational or distorted severe mental illness.